Welcome back to your course on fundamental rights in the Indian Constitution. In this video, we will discuss the right to freedom of religion. Articles 25 to 28 guarantee a set of rights that can be collectively referred to as the right to freedom of religion. Secularism is a foundational value of the Indian Constitution. This is clear from the preamble to the Constitution, which speaks of the people having constituted a secular republic. The preamble, as originally enacted, did not mention secularism. It was added by the 42nd Amendment to the Constitution in 1976. There is, however, enough historical and textual evidence to claim that secularism is a foundational value of our Constitution. Religion being one of the main issues that led to the partition of India, the framers of the Indian Constitution were acutely aware that the new Constitution should not discriminate among the different faiths. While this much was clear, the other implications of secularism in the Indian context were fiercely debated in the Assembly then, as it is often debated today. Whether the Western notion of secularism fits a nation with a deep spiritual history, such as ours, was an important question during the debates. Secularism in the West, a good example of which is France, refers to a rigid separation of the state from the church or religion. In America, a similar separation is mandated by the First Amendment, a part of which is called the Establishment Clause, which prohibits state endorsement of any religion. This is the model of secularism in Turkey as well, which has come under some strain recently. By contrast, India has always been hesitant to espouse any such rigid separation. The central principle remains that the state should not discriminate against or favor any particular religion. In a 9-judge bench decision in S.R. Bommai, the Supreme Court also seemed to endorse a similar view of secularism. The court also noted that secularism is a basic feature of the Constitution. The court further stated that the amendment of the preamble merely made explicit what was earlier implicit. Articles 15 and 16, which prohibit discrimination on the grounds of religion amongst other things, as we have seen, and Articles 25 to 28 were seen as textual evidence for this claim. Even though the preamble did not mention secularism, it did mention that the Constitution seeks to secure to all citizens liberty of thought, expression, belief, faith, and worship. With that background, let us now read Article 25. Article 25 guarantees the freedom of conscience and the right to freely profess, practice, and propagate religion. Note that this right is a qualified right subject to A. Public order, B. Morality and health, and C. Any other provisions of Part 3 of the Constitution. Clause 2 of Article 25 specifies the grounds and extent to which the freedom can be regulated or restricted. The article also has 2 explanation clauses. One, for example, protects the practice of Sikhs carrying kirpans or small knives, and the second clause, which perhaps inaccurately includes Sikhs, Jains, and Buddhists within the Hindu fold. 2 key concepts that define the breadth of Article 25 are conscience and religion, as Article 25 guarantees freedom of conscience and propagation of religion. The freedom of conscience refers to the rights to one's beliefs, including the right to believe in a religion of one's choice. As held by the Bombay High Court in 2014, it includes the right to openly declare that one is an atheist or that one does not believe in any religion. In the case of Ranjit Mohite, the government printing press was directed to accept the request of the petitioners to notify in the official gazette that they do not believe in any religion. The controversial question of whether there is a right to convert has been answered by the Supreme Court by referring to the freedom of conscience. In the case of Reverend Stanislaus, laws made by Orissa and Madhya Pradesh punishing conversion by force, fraud, or allurement was challenged as unconstitutional. The Madhya Pradesh High Court rejected the challenge, while the Orissa High Court held that the Orissa law was invalid. The Supreme Court held that the right to propagation of one's religion does not include the right to forceful conversion, as it would impinge on another's freedom of conscience.